Hi everyone, and welcome to such an auspicious year, 2020. It's a once in a lifetime event for us. Certainly the last time that the numbers align like that was in 1919. I can't wait for the 20th of February 2020. That's going to be a big one as well. So we're going to have a lot of fun this year. And you've probably seen, for those of you who have been reading my emails over the last, I think pre-Christmas, I've been putting out an email each and every day around self-managed super funds, but mainly succession and estate planning. That for me, much the same as I saw the growth in SMSFs, particularly from 1999 onwards, and built Australia's first ever SMSF advisor course, which then I remember the session we did in Manly in 2001 became the SMSF Professionals Association out of that course. Likewise, I see that over the next 20 years, the big growth will be in succession and estate planning advisors. Now, SMSFs will have a great big place in it, which from my perspective is that those advisors should come from the ranks of accountants and financial planners as opposed to lawyers, because lawyers don't have the wherewithal, the expertise generally in relation to self-managed super funds. So I've gone through previously the moat, which includes obviously deed upgrades, wills, includes EPOAs, etc. Now we're going to do a deep dive into the SMSF Will. I'm going to give you a bit more of a background of where it's come from. I'm going to look at a case study, and we're going to look at how to ensure that the SMSF estate of our clients effectively is not caught up in the any Family Provisions Act, or up here in Queensland, the Succession Act. Depending on which state, we want to make sure that it doesn't go in there. If you read the story, I think I've got it here on my desktop. So you're actually looking straight over my shoulder here. Let me just go straight to it. I think I've got up here. Oh yeah, this is a famous case. This is a great case for us all to read, and really has given me the impetus of where we're going down the track. Now, this is not a self-managed super fund case, but it's the Supreme Court of West Australia in 2018, so it's very, very new. Angela Miller versus Elizabeth Desiree Taylor and Andre Philip Taylor, which were the children from the first marriage of the deceased, versus Angela Miller, who was second spouse. Now, of course, that sounds very much like Donovan and Donovan and all of the cases there. So the fact we've got blended families these days, either up, middle or downstream, essentially means that, you know, we've got to be obviously very concerned about what is going on. Now, in this case, I won't go through it. I have gone through it extensively. The key issue, though, out of it is we should have like a little summary judgment here. So Andre Philip Taylor died on 28th of July 2013. So it took 5 years. As you can see, 5 years is a long time. Now, the plaintiff, Angela Miller, seeks provision from the estate of Andre under the Family Provisions Act. Angela was born in 1944. She's presently 73 years old. She said that she was in de facto relationship with Andre at the time of his death. Andre and his ex-wife, Elizabeth, the first defendant, and 2 children. Generally, in a lot of these Family Provisions Act, ex-spouses do have standing in order to sue the estate. So in this case, in the WA case, and certainly New South Wales, the ex-spouse has done so. Now, they had a will, and effectively in the will, there was a property, which was the family home, with $600,000, which was left to Elizabeth Desiree Taylor and Andre Philip Taylor, which is his children. Now, in this case, Angela Miller effectively was in a position of challenging the estate. Now, as you can see, he died in 2013. This case was in 2018, so it went in 5 years. I just want to show you something. It's a $600,000 estate. And I just want to show you, they ended up awarding Angela Miller $220,000 out of the $600,000 estate. But I just want to show you something. I shouldn't be laughing, it's disgraceful. Let me go through. So they went through all the income needs and all of that before she came to an award. But here we go. So you can see there, they're making provision of $220,000 for Angela. Now, the main thing is, now she's found the value of the estate at the date of death was $675, but as the date of the trial, remember this is 5 years later, was $600,000. So again, that was from the sale of the assets. Now, she then goes in, like this, it's a $600,000 estate. I was unsettled upon entering court on the first day to see 6 persons seated at the bar table. Given the value of the estate at trial, $600,000, that represented 1 person at the bar table for every $100,000 of the estate. On no possible basis could the size of the estate and complexity of the matter justify 6 persons. In a state of this size, in any state under $2 million, unless there are unusually complex issues arising, counsel should be able to do the matter on her or his own without an instructing solicitor. If they cannot, they should not accept the brief or take instruction. Anyway, she goes down and has a look. Now, here's the fees, $140,000. That's in relation to Angela. So the defendant's total, and also looked at work in progress, was $342,000. Now, then we have a look at the other one. If we have a look at the other, in total, was $502,000. And we've got solicitors, Victoria, etc. coming. So the issue I raised there for you is that on a $600,000 estate, there was more than $500,000 being spent in legal fees, and that didn't include the appearances at that day of the 6 persons. So effectively, there was no estate. Not only will the children who were promised those monies in the will miss out, and the provision that Justice Courtois made in the WA Supreme Court that she should get $230,000 missing out, everything has gone to the lawyers. Now, the worst thing about it is not only has the lawyers ravaged, raped, and really, from my perspective, stolen from the estates with nothing left, and this is only a small estate, but they did not receive any sanctions. They got a rap on the knuckles, as you can see at the end by the judge. But apart from that, there was no disciplinary action. And to me, that just, look, I'm just flabbergasted on that. And I put it to you, and this is where I get passionate about it, because these are families that are being affected, that if this could happen to a $600,000 estate, and think of how many people over the next 20 years will potentially pass away with a family home worth and other assets worth $600,000 or more. I would have thought there's going to be a huge amount. On an estimate, if we have a look at some statistics that I've reviewed, there's $3.2 trillion, so this is not 3.2 billion, $3.2 trillion, which is to pass between generations over the next 20 years. And much the same way in 1999 and 2000, I saw SMSF as a growth curve, and they did. In those days, they were around about $110 billion. They're now $750 billion. They will not go to any great extent anymore, mainly because all the smart people have gone in with the pension T-bar. They're now moving out of those processes. In fact, having a retirement accumulation account, so that's accumulation account running alongside a pension account, to me, is very, very dangerous tax-wise. And we want to make sure we address that through the use of leading member discretionary trust, but that's for another discussion. So I see that if we look at the SMSF sector, and look, it is absolutely crucial because there are a lot of clients with SMSFs, and we need to make sure, one, and this is my first motto that I can give to you, the first theorem or Grant's theorem on succession and estate planning is, by all means necessary, keep it away from the estate. You see, if it doesn't go into the estate, how can it be challenged? And the beautiful thing about a self-managed super fund, I remember having discussions on this with Peter Rule from Complete Business up here. He's a Sunshine Coast local, that what we can effectively do is we can make sure that, unlike, it doesn't have to a superannuation doesn't have to go through probate, doesn't have to go through all the shenanigans of having an executor. We can pay it out virtually within a week of the client dying, provided we've got a process and system to do so. So that's our job as advisors, to not only set these things up, but to administer them, wind them up really quickly. So as I said before, SMSFs are important, but they're only $300 billion, which is switching. So for some of you who want to stick to the SMSF sector, absolutely. You know, I would say that, look, it's perfect, but if you ask me, it's a very, very mature sector. What we're looking at now in terms of succession estate planning is very nascent. It's on a super growth curve, very fast growth curve, and clients don't mind paying fees for protecting their estate and their family's wealth. So I've been talking about this for quite some time. I've got a 2-day conference coming up in the Novotel up here on the Sunshine Coast on the 23rd and 24th of March, which I'll talk about a little bit later, but I'd certainly like to see you all along at that. Now, when we turn our attention to superannuation and self-managed superannuation funds, which is obviously fairly important for all of that, what we've got there is BDBNs were introduced in 1999, and I want to take you to the regulations around that. At the time of the big changes to superannuation, including the move of the regulator from APRA to the ATO, they are severely limiting in what they can do, as we will see from the legislation. They are not, listen, they are not secure, certain or safe as the BDBN cases show. The danger is, when I review trust deeds, I find a lot of trust deeds, notwithstanding that the BDBN laws do not apply to self-managed super funds, and we'll look at that when we get the Commissioner's ruling. What we find, though, is they build those laws into the deed so that we actually have Regulation 617A going into the deed. And once we do that, it then becomes very problematic, as we can see. I remember going to Class Super and listening to Dan Butler going through BDBNs, and he went through about 10 cases. And I tell you, at the end, if anyone had a BDBN, I'd be absolutely scared. Hence, I've dusted off, not dusted off, I always had a thing, is an SMSF Will, which is essentially just a document, a set of directions, which I'll go through in detail for you, which lays out in a contractual manner that binds current and future trustees as to what is to happen in the event of the death of a member. Now, it does follow, and for most of you, you're going to get it really easily, because it is like it's a mix and match of best bits of a will and the best bits of a BDBN, which you're already comfortable with. But it's not too difficult to understand. What I've done in drafting it, I've put down some specifics, but then opened it up to generalities, which would arise after the death of the member, where essentially the trustees and potentially the leading member looks at it. Now, as I said, the ATO has said that BDBN laws do not apply to SMSFs, and we'll have a look at that. So we need to go to the governing rules, and from that, we can build the relevant documents for passing along benefits. So if my client's deed says that I have to do a BDBN in line with the superannuation laws, or in line with 617A or whatever, then I have to go in and turn in, I've got my 2020 legislation here, make sure you get a copy of that, the super legislation, and I have to turn to that, and then I'm going to have to apply 617A to my client's circumstances, which is a bit of a drama. Now, the key to safety, certainty and security is to keep things from the estate, where challenges can be made by children, as you can see in Angela Miller's case, where the de facto spouse of Andre Taylor had standing. Financially dependent grandchildren can even make a claim, and even some states ex-spouses. So if we have the traditional, and look, you all know it because you've been to lawyers, traditionally lawyers will transfer, if you're an estate planning lawyer, monies from an SMSF into an estate. And the danger about that is that, hopefully you can see this, I'm structuring for succession. If I go from there to there, so, oops, sorry, let me go back. If I go from the SMSF into the will, then instantly, if I go into the estate and I can build these beautiful testamentary trusts like the ones that we have in our SMSF will and inbuilt testamentary trusts, I can do all these amazing things. But that means nothing, because as soon as it jumps that hurdle, then the Family Provisions Act can take on. And if there's a family provisions claim, expect at very minimum 10% of the estate to be taken up in legal fees. Now, of course, you're always going to find a lot of people with standing who are going to feel aggrieved. So that may well be the grandchild, the daughter, or it even might be the adopted child or the stepchild. Anyone may fall in there to be caught. And as soon as we do that, and we can find, and you've seen all the ads where lawyers say no win, no fee, challenge the estate. Now, of course, and the danger about it is, from a legal perspective, is that to place a challenge on an estate, you're not going to a magistrate's court or a district court where it's fairly inexpensive. You're going to go to the Supreme Court. So that means at very minimum, it's going to be, if you do make it to the court, like we did in the Taylor case, if you end up going to court, it's going to cost a lot. You saw in the Taylor, remember, it cost $500,000 plus out of a $600,000 estate. So the very idea for lawyers is to drag this on as long as possible and just leave the case file open. And every time they pick it up, obviously there's going to be a fee there for you. But if there's a combat, as soon as you cross over that, you're in the Family Provisions Act, Succession Act, or whatever, that's where we don't want. So lawyers, and don't you find this is crazy, because lawyers get us to do a binding death benefit nominations, we've already said a week, to transfer assets over to an estate where there's potential for a challenge. So lawyers are feeding lawyers. Where we want to go is keep this localised. So what we're going to do is look after all our SMSF needs, and instead of doing a testamentary trust through here, we want to pass everything down this way. Does that make sense? There may be some limiting factors, but we want to pass everything from the SMSF down to the spouse, down to dependents. An assist dependent includes a child. Now, they may not be a tax dependent where they get the tax benefits, but they still can pass our benefits directly here. The same way with pensions. Pensions can be commuted, I don't know where that came from, commuted and passed directly out. So in our SMSF will, we want to keep a really tight, certain and secure box that monies go here. We can in fact have on our estate monies going from an SMSF into an adult child's discretionary trust if we want. Or we can build a brand new discretionary trust like a leading member discretionary trust and call it the Andre Taylor SMSF Death Benefits Trust. Again, they're built under here, not through here in the will. So that's absolutely crucial. But let me move on and start to look at some cases. So with the SMSF will, we need to have a look at what your SMSF deed. Now we've got the two, we've obviously got our standard SMSF, and for me, the more protective leading member SMSF for succession planning. In both cases, as I said, it's a contract between the member and the trustee of the fund. If you're not using one of our deeds, it's a fairly simple process to upgrade not only the deed itself, which I'll talk about, but also the corporate trustee, and I'll cover that shortly. So we're going to have a look at what the rules of the fund say, and importantly, we then start to build this SMSF will, which is a contract. The contract forms part of the governing rules because it's like an addendum to your trustee. And why do I say that? It's simply because that's the way that the SIS Act works, section 54C, and also the definition of governing rules. And it cannot be breached. Now, any party who breaches, and this is important, any party who breaches any part of the SMSF will contract will be liable for losses occasioned for the breach. And if they have deliberately done so and received a financial reward out of it or financial recompense, there's a potential criminal referral under section 202 of the SIS Act 93. Now, this doesn't apply just to trustees, it applies to any person. So lawyers, accountants and auditors, beware. Now, I've got the key concepts, which I'll have a look at. What I'll do is I'll just jump out of here if you don't mind, and I want to have a look at the Commissioner's guidelines in terms of, so this is the section that we're looking at. So I'll have a look here just quickly. SIS Regulation 617A, which applies to 59(1)A. So basically it says for subsections 31 and 32, the standards set out, subregulation 4 is applicable. For subsection 59(1)A of the Act, the governing rules of fund may permit a member of the fund to require the trustee to provide any benefits in respect of the member on or after the death of the member to the legal personal representative or dependent of the member. Now we want to trying to go to the dependent, because remember, if it goes to the legal personal representative, we've crossed that red dotted line and we're potentially open to action. Now, the trustee must give the member information the trustee reasonably believes the member reasonably needs for the purpose of understanding this is the binding death benefit nomination. Although it doesn't say it in there, that's what the term is. Now, subject to subregulation 4A, so this is the process and these other regulations, which 7A effectively applies for family law purposes. If the governing rules of a fund permit a member of the fund to require the trustee to provide any benefits in accordance with subregulation 2, so it's the binding nature, the trustee must pay a benefit in respect of the member on or after the death of the member to the person or persons mentioned in notice given to the trustee by the member if, now let's go through, the person or each of the persons mentioned in the notice is the legal person, representative or dependent. So it actually has to notify where it's going to go. So we could put 50% of our estate going to our what's name. But here's the thing, and the proportion of the benefit that will be paid to that person or to each of those persons is certain or readily ascertainable from the notice. And the notice is in accordance with subregulation 6 and the notice is in effect. So if I've got, for example, we're going to look at a little bit later on, we've got Dad, who's John Smith, who's a doctor, and he's got a son, Matthew Smith, who's also a doctor, and also a daughter, Marie Smith, who's a doctor. And he's got rooms, medical rooms in his SMSF, and he wants to pay them out or transfer them to Matthew. Then we've got a problem, because if we're relying, if the deed says that we are to apply SIS Regulation 617A, then we can't do that, because binding death benefit nominations only allow proportions of the benefit. So that's crazy, because we've got this, I mean, it's like, when I have a look at SMSF Wills, and we'll look at it shortly, it's like having the best McLaren, or in fact better. I'm a Mercedes man. I don't know if you saw that new concept car, the Avatar Mercedes. Look, it's amazing to see what could potentially come down the future. But if in an SMSF we're using this clunky old version, it's like someone getting a Toyota, or what is it? Which one does it Gets? I don't even know who has it Gets, but like a Suzuki, one of those really tiny Suzukis. And that's what we're saying, is that's what you can use for a self-managed super fund. You see, BDBNs were mainly made for large public offer and also industry funds. But there's so many, in fact, at least 50% of SMSFs fall back in here. Now, the thing I worry about here is because it says subject to subregulation 4A. The trustee is not required to comply with subregulation 4 if the trustee is subject to a court order that has the effect of restraining or prohibiting the trustee from paying a benefit in respect to the member in accordance with a notice of the kind described in the subregulation. So I look, again, the Family Provisions Act, etc., can't really have an impact on superannuation. And I know there's been a lot of stuff around the nominal estate for the Family Provisions Act under New South Wales, but it doesn't apply to superannuation. It may take into account superannuation, there may be adjustments outside, but there is no way a court outside can make an imposition on a self-managed super fund, which is governed by the SIS Act and the Tax Office. A state-based legislation cannot override the SIS Act. So effectively what we've got there is we've got the legislation, and I just want to show you quickly, I think I've got the Commissioner's guidelines here. So this is the SMSF determination. Is there any restriction in the superannuation legislation of self-managed super fund trustee accepting from a member of binding death benefit nomination the recipients of any benefits payable in the event of the member's death. So this is SMSF-D 2008/3. So let's go and have a look. No. Now this is important. Section 59 of the SIS Act and also regulation 617A of the SIS regulations do not apply to self-managed super funds. So there's a case Donovan and also this determination saying it doesn't apply. So we're in a good position, which is crazy because why would anyone in their SMSF deed import 617A when it is extremely deficient in what it can and can't be done? But again, the people who have drafted those deeds obviously haven't got a huge idea. This means, and if I have a look, in fact, I'll highlight this for us. I might as well highlight it now because that way I can use it for, I'll be able to use it for the course coming up on the 23rd and 24th. Look, if you can make it to that, look, the accommodation's only like $140 or something a night, and trips up like through Jetstar and all that are so cheap up here. I think my daughter just got up here for like $129. It's crazy. Okay, so this means that the governing rules on SMSF may permit members to make death benefit nominations binding on the trustee, whether or not in circumstances that call with the rules in 617A. So again, people have taken 617A and ported it in, but it seems to me it's been pretty lazy. However, a death benefit nomination not binding the trustee to the extent that it nominates a person who cannot receive a benefit, so that's pretty obvious. We then go down to the explanation. The payment of death benefits, now this is, I love this one thing. The payment of death benefits from a super fund is determined in accordance with the governing rules of the super fund and not in accordance with the terms of the deceased will. Now, I had a stand-up fight, can you believe, with a lawyer only probably what we were doing just before Christmas, who could not believe that superannuation was not able to be directed through the will. I said, of course, it can be directed through the will, but the will is governed by state legislations like succession acts. Here, the Commission's got a ruling, and there's also Donovan's case. So trustee of his estimate cannot abrogate their responsibility in making decisions with respect to fiduciary functions, except as authorised under the governing rules of the trust legislation. When undertaking their duties, trustees must act good faith and reasonably. So anyway, we won't go through this. What I want to do now is actually go, I'll have a look at the case study, then we'll go into the deed, and then we'll go into the SMSF Will and build one for you. So I'm just jumping back there. So we've had a look at SIS regulation 617A. If our deed's got that in there, upgrade the deed immediately. In fact, I would suggest that you want to upgrade your client's deeds anyway, if you're going to go down this track. If I have a look here, so with the SMSF Will, the key concepts that you're going to see, you can pay specific percentage to dependents, but under the deed, we can actually provide specific assets so that if there's a farm or there's a property or, for example, shares in a private company, if we're allowed to have those in there, they can be transferred directly to a beneficiary. Now, what we want to do is we want to try and pass everything, remember, out of the estate. We want to make sure that it comes through the SMSF and not into the estate. So you can go deep and transfer specific assets. Now, it can be paid as a lump sum, income stream if it's allowed. Now, just because a child at the moment cannot receive an income stream doesn't mean that's the case in the future. Now, it's funny, brothers and sisters who are financially dependent on the member can receive an income stream. Parents who are financially dependent on the member, such as in Malik's case, where the mother was held to be financially dependent on her 19-year-old son because his board of $200 a month increased her standard of living, the mother could have received a pension. It is only a child who is over the age of 18 or 25, if they are not financially dependent, who cannot receive an income stream. Everyone else who's financially dependent, including financially dependent grandchildren, who could make an action under a Family Provisions Act, they can be provided directly through the SMSF and income stream. So we want to make sure we've got that opportunity, or as I said, a death benefits trust, which is a discretionary trust. And I'd be using the leading member discretionary trust, which pops up and is payable on the death of the member. And generally, when we have a look at that, which payment we're going to make, lump sum, income stream, or death, that's going to be where you come in, or your firm comes in and provides advice to the trustee of the fund. And if it's in a standard SMSF, then it's the trustee that makes the decision along with the beneficiary. If it's a leading member, then it's going to be a leading member along with the beneficiary. And as I said, because it's a contract, we contractually insert into the SMSF will yourself or your firm's name, such that on death you're able to be paid a set amount in order to deal with the SMSF estate. Much the same as lawyers. In fact, I just saw a lawyer, one of our advisors and in fact shareholders in our company, showed me that one lawyer to administer the estate for a client was going to charge $45,000. I'd certainly say you shouldn't be anywhere near that, but essentially we want to be in a position of making sure with the SMSF estate we can get it, pay it out and set it up really quickly before it even gets to before the will is even sent to probate. So let's have a look at a quick case study and then we'll go in and have a look. So we've got John Smith, age 57, still working as a doctor with 1.4 million in super. So obviously can't start a pinch at this stage. And his wife Sally's age 48 with 600,000 in the Smith SMSF. So they're in a really good position, obviously keep on contributing, but they will be locked out at some point in time because they can't go over the 1.6. The fund is invested in shares, medical rooms, which are leased to the medical practice, and 400K in cash. Son Matthew is aged 33 and also a doctor in his father's practice, who's been married to Beth for 10 years and has 2 children. Now, when we have a look at this, obviously Sally's 48, so she didn't have a, Matthew at 15. Sally's in fact the second spouse. So again, we're putting in this blended family concept. So son Matthew is aged 33 and also a doctor in his father's practice, who's been married to Beth for 10 years and has 2 children, Ben and William, both under age 10. Daughter Marie, age 28, lives in Adelaide, is also a doctor and is single, has $50,000 in Rest Super. Matthew has $140,000 super with AMP and Beth has $60,000 in BT Super. So if we just go down the track and have a look at from a Family Provisions Act perspective, if all of this money went to the estate, so the $1.4 million, so John dies, it all goes to the estate, so everything's fine and dandy. Who can make a claim under the Family Provisions Act? Well, first off, Sally can, because Sally is the de facto, well, not the de facto, is the second wife, so absolutely. Matthew can, also Marie can, so they're both children. Potentially, both Ben and William can also make a claim under the Family Provisions Act if monies have been going from John to look after both Ben and William. So it doesn't have to be financially dependent or wholly or partially. It just has to be, there has to be some sort of financial recompense. Again, it's going to depend on what state that you happen to be in. Now, likewise, Matthew and Marie's mum, who is not Sally, who I haven't put in this case, could also make a claim depending on the state. If it's New South Wales or West Australia, absolutely, they can all make a claim. That's if the monies from the SMSF go into the estate. So it seems to me it doesn't make sense. So what we need as advisors to drill down and determine that when we start going down, what does John want exactly? So when we have a look at John, as I said, we've got all this money sitting in here. It's just a refresher. If he dies, the property and fund is to go to his son Matthew so the practice can continue. So the medical rooms are 1.2 million, which don't have an LRBA, are to go directly to Matthew. Now, again, if we put it in through the estate, so if we give it to an estate planning lawyer, they'll put it into the estate, and then what will happen is they'll set up a testamentary trust for Matthew, and of course, Beth and also Matthew's 2 children, who are John's grandchildren, will probably be beneficiaries of that testamentary trust. But the problem with that is what? Is that once it's transferred over, let's go down a little bit further. First off is Sally could challenge it. John's ex-wife could challenge it. Sally's to get the remaining 880K. In fact, it's not 880, so that's just a typo. It's 800K. So let me just go out of that. So I was rushing to do these this morning because I had a couple of articles to get out. So Sally's to get the remaining 800, plus she's also got another 600 in super. We'd have to look at what else is sitting outside the estate. So the question there is, again, you know, from that perspective, is has she been well looked after now, all that went to the estate? Now, Marie's going to get nothing from super, but she's going to be left an investment property in the will. Now, recently, Marie and Matthew have been fighting, and she thinks it's unfair that Matthew's getting the medical rules. Remember, Marie's the doctor, but knows this is what John wants. She told Matthew that it'll be over her dead body. So the first thing that we know is if that property goes into the estate, expect on this one at least, it's going to take, once it goes into the estate and there's a challenge and Marie decides to challenge. Now she's the doctor, so she can afford the fees for a challenge. It's probably going to take at least 3 years to settle. And I would expect on, you know, 1.4 million, probably around about $300,000 easily in fees. It's not going to be as so abhorrent as the Taylor and Miller case, where it was effectively the whole estate. So we're not going to lose the whole $1.4 million in fees, I don't think. But essentially, we're going to be there. So let's just jump out of there. We've got an idea of what we've got. We've managed to elicit from our client, well, this is what we want to happen. Let's go and have a look at what we can do. So the first thing we want to do is we want to go to LightYear Docs. We want to have a look at our deeds. So you just go down to SMSFs. So SMSF established, maintain, and upgrade. Now, I'm not going to look at that. What I will do is I'll just have a look at this automation. So where we've got an automation, we can upgrade our SMSF deed and corporate trustee to leading member. So what I'm going to do is I can either do that, and I'd prefer, honestly, seriously, to do the leading member. But what I'm going to do is just show you the basics at this stage. So this is just stock standard basics. So the LightYear Docs SMSF trustee is simple, easy to read, and covers a wide range. So what I'm doing is 2 things here. So I'm going to use the Abbott-Family. So when you use this system, make sure you press on the green. That'll open up my folder. And up will pop, and I'm actually going to do it from scratch. I probably should have done it earlier, but it's not going to take that long. So I'm going to put the Smith. Let's the upgrade. I'm going to upgrade the company as well. Now, for those of you who are using our system, you can either have your own logo. Here I'm using the Abbott-Morley, which is our company. I don't know if any of you saw that View Legal, which is the document provided the legal firm and signing off with Now Infinity, has broken all ties with Now Infinity. Anyway, so we've got a special purpose company. So this is our trustee. So we'll call it Smith Super Nominees. And we go 1, 2, 3. 1, 2, 3. 6. We've then got the address 5. Sorry, my typing's hopeless at the moment. I've got a new desk for Christmas, and I'm not sure that it works that well. Okay, 2,000. So we've got 2 directors plus. I would have certainly, the first thing I would do, not sure about Marie given the fact, I would have as directors, definitely John Smith. We know it has to be Sally Smith because she's a member of the fund. And of course, if John had her EPOA, she doesn't need to be a director. And I would now bring in Matthew Smith with his superannuation as well. Now we'll get them all to sign. So if you don't include that, they don't sign. So what's the existing, what date is the existing company constitution? So let's say the client's coming in tomorrow. So it's the 10th of the 1st, 2020. Just, it's amazing, 2020. Now, what we do is, let's say that we've got John Smith is the sole shareholder, and also the meeting. Each trustee meeting, now this is important, so because there's a corporate trustee, do you want to have a vote each with a chairman having a casting vote? So given the fact that we've got John and Sally and Matthew and John would obviously go together, there's 3 of them, I would go a vote each with the chairman of the casting vote at that stage. Now we've done that, so that's a company, so we've upgraded the constitution and we'll go through that. What's the full name of the fund? We've got the Smith Family SMSF. We'll put it in New South Wales. What date it's going to change? Now we know they're going to come in, so it's the 10th. What date was the fund originally set up? So we go and have a look at the deed itself and find out when it was set up. So it could have been 2013. It hasn't been varied in the past. So all I need to do is just go to the last deed. I can say, okay, yes, well, it was varied on the 4th of the 6th, 2018. So I keep on adding a variation dates, a deed of variation. So then we go to our next. Oops, sorry. What have I done? Oops, please enter a valid date. As you can see, it's very intuitive. So what's the clause? I looked through the clause. Let's say it's 3.21. It gives me the opportunity of working out the trustee being able to upgrade the rules of the fund, which effectively means we throw it out. Now, you might find that does the trustee variation clause need another person? So we could, for example, it could be a leading member or whatever, but we're going to assume it's no here. So that's the case. Remember, you've always got this document preview button here. So I can actually have a look at the document or all the answers next to it there if I wanted to. So that's my document I can look at. If you're on like me, an LY strategist, so you've got unlimited docs, I just actually take it through. I don't need to go through a document preview. But if you're going PAYG, you should do a document preview. But remember, you can always go back and relaunch it. So we go back. Let's have a look at the documentation. So I finished it. It's now being jammed up. It's gone through the system. And again, thank you all for supporting us. We've had some quite rapid growth over the last few months, which is pretty exciting. And of course, so here we have it. So we've got the constitution upgrade here. So just a couple of things I want to show you. So that's what this does is just you have a meeting, the members, and the members just mean the shareholders. So John's the only shareholder. So again, go through if you're already on our system, just go through and do one out as a demo for yourself. Now, so we've got a new constitution here. Now, we've got here the company's a trustee of a superannuation fund. I've got all the directors, so on and so forth, powers of directors, meetings of directors. So when we have a look, we've got, you know, quorums, etc. Must have at least 50% of balances. So we've got presence, we've got proxies, circulating minutes. So if a member of the fund dies, so this is really important. If a member of the fund dies, the member's legal personal representative is to be appointed as a replacement director of the company. So what does that mean in terms of John? And then you aren't not going to find this in any other corporate trustee for an SMSF. What that means is built into the constitution is that if John dies, and let's say Matthew is the executor or you're the executor, you are to be appointed as their legal personal representative. You're the legal personal representative, then you become a director of the company. Failure to do so within a reasonable time requires the company to cease acting as trustee of the super fund. Now, this is important. At any meeting, where the disposition of deceased members' super benefits distributions to be discussed and resolved, only that person appointed as deceased member's replacement director may vote on any resolution. This also applies where a person's incapacitated. So what I've done, and I've built it in legally into the documents, is that on the death of a member, the executor is automatically appointed as their replacement director, and they are the only ones who can vote on the distribution of their estate. And that's a pretty crucial. So have a look at yourself. It's rule 7.9. Because what that does, that provides a safety, certainty, security. So for example, if we were in the SMSF there, we've got a corporate trustee, John dies. Let's say Matthew comes in, then Matthew comes in as replacement director for John, and Matthew is the only one who can make decisions around the disposition of John's death benefits. Sally is a director, but she has no power when it comes around to meeting around those death benefits. Again, safety, certainty, security. I won't go through the rest of the Constitution. We'll go and have a look at the SMSF. So we've got the deed of variation. So where I got it. So this is the PDS. So this is the SMSF trustee, the variation Smith family. I'm going to go through blah, 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 blah. So that's the PDS. What I want to look at now is in terms of the members. So members, individual subfund. If the member creates subfunds for the members under these rules is allowed, blah, blah, blah. We include power of attorney. We can also do the member directions as disposal of super benefits as an SMSF will. Something going to come down a little bit later on is mental incapacity. That's not for now. That's going to be towards May of this year when we go out and do our Round Australia Roadshow. That's going to be the SMSF living will. So effectively, we've got a position now we can do SMSF wills. So that's built into the thing. Same thing happens in the obviously the leading member. What I want to do now is let's jump out of there. Go back to LightYear. I'll go back to the home page, and we're going to now do the SMSF will, which pops up there. So I go to my estate planning, start document. I've got the Abbott-Family, which pops up there, and then we start. So we're going through now. I'll take you through as we go through. I'll go slowly. I'm going to go a little bit over time, but not a huge amount. So we're going to do the John Smith SMSF. Now we want to put this in because this is when we go into our vault. It shows us easily the document that we're working on. Again, you saw in the documents I did before the Abbott-Family. If I leave this blank, then nothing comes up. So, and you'll never find a LightYear Docs logo on that. So we've got the member. We know the fund is called the Smith Family, SMSF. Now, what we do is we don't know, so there's a date of application that John has to make to the trustee. Even though he's coming in to do his deeds tomorrow, I don't know when he's going to do his SMSF will. I'd like to get this down and show him in draft, but then probably get him in next week to have a good look over it. And then what I do is I'd come back and then I go back into the vault, look at the document, then I would go and put this date in if he's coming in this morning, and we'll do that. So let's say that we've done that and he's coming in next Thursday. So I go in and I'm putting in John Smith, 5 Smith Street, Sydney, New South Wales, 2000. Okay, now we start to get to it. We know it's a company. So it's Smith Super Nominees. I forget what I put in. Remember, I had like these. Sorry, my ACNs aren't working for me today. I go back 5 Smith Street, South Wales, 2000. Remember, we had 2+ directors, so I put in there 3. Confirm. So I've got John Smith, I've then got Sally Smith, and then I have got Matthew Smith. Now remember, again, because we've upgraded the constitution, Matthew, if he's the executor of the estate, is the only one who's going to be able to deal with that. Compare that, I mean, if I didn't have that clause in there, then one is that there's no power under the general deeds for Matthew to even be a replacement director. But anyway, it doesn't happen with us. So we've got 6 questions. Does the member want to revoke earlier nominations? So there might be an earlier BDBN, so absolutely want to get rid of that. Does the member want a reversionary pension or pensions to take precedence? Well, at this stage, he has no pension, so we go no. Does that make sense? So there's no pensions. If he's already got a reversionary pension, let's say it's 5 years down the track, then we might want to say yes. Does the member want to appoint the executor as a replacement trustee? Yes. Now, the hard thing about that is that has to correlate with the company. Now, with this one, we can use an SMSF Will for other trustees. It doesn't really make sense. It's probably better to upgrade. I mean, you saw there what was the costing that we had for, if I just go back and have a look here. So I'll go back to the strategy automation. So the corporate trustee and deed upgrade, the cost on that was $129. So when we have a look at that, I mean, you know, why wouldn't you upgrade both of them anyway for that perspective? So let's go down. Does the member want to include death benefit payments? Yes. Does the member want a professional voice? That's yes. And if the fund's held non-compliant, you want to escape all clause? Yes. So then we go down to death benefit payments. So we've got the beneficiary. So the first one is Matthew Smith. His relationship is as the son. Now, what's the asset? So these are the medical rooms. And look, I'll show you what you can do. There's just a couple. This leaves us wide open. So let's say the medical rooms at 10 Smith Street, Sydney, New South Wales, 2000, to be paid into a SMSF Death Benefits Trust only. So what we're doing there is we're saying the medical rooms, we have to create a trust, and it's a discretionary trust on the death of John, and those rooms have to be transferred in. So we have to watch out for, obviously, stamps and CGT. Now, in the event the beneficiary is not alive, the succeeding beneficiary is who would you make the succeeding beneficiary? I would say that we could make it Marie Smith. Or alternatively, we can put Matthew Smith's, actually I'll say lineage children, yeah, bloodline children, if they are dependent upon the deceased member. So it means that it goes to Matthew. If not, it'll go down to his children. Now, if it goes down to his children, I'm going to show you there what happens a little bit later on. Now, if neither of those are alive, it can go into the deceased estate for the family benefits, or it can go into the deceased estate for the sole benefit of deceased bloodline or lineage, unless SMSF Trust death benefits can be established under the super laws of the bloodline or lineage. Now, what that means is I can either just throw it into the estate, or I can possibly put it into a death benefit trust. So what I would do there is, if these kids and that don't go, then where's it going to go? It means that if I click this, it's going to be for the benefit of Marie, who's the other child, because she's going to be the bloodline. So I've covered that. Now, so that's the first one. Second one I've got is, I don't know what Susan came in. Susan, Sally, Smith. Now, relationship is spouse. Now, I can either do, at the moment, I could do $800,000 or whatever my superannuation balance X other dispositions. Okay, so now if Sally's not there, then it's unlikely it's going to be Marie. Who knows? So it could be, let's just say it does go to Marie Smith. Now it can go to, if neither of those are live, then again, we'll just put it into the deceased estate. Now, of course, you can do this down the track. You could have, like, for example, Matthew's to get 50%, but it's got to go as a pension. Sally's to get this, it's to go this. The grandchildren are financially dependent. They're to get income streams if they want to. But we'll have a look at that shortly. I'm just running out of time. So the professional, I am going to change this a little bit later on, but let's say it is John Jacobs. So, and then what we're going to do, normal, because you're going to be a specialist estate, succession estate planning partner. Firm name, Jacobs Accountants, and then you put your address there. So 100 Jacobs Street, Manly, New South Wales. I'm not sure where it is, it's 2032, let's just say. We have the meeting. Again, we don't know when the meeting is, but I think we said the 16th, so we get them all in next week. John, Sally, Matthew. John chairs the meeting. Remember, we changed it over. Now, because we've been there before, we just simply select, and up pops Sydney. Oops, sorry. I've got that address wrong, so trustee. So just fix that typo, and then effectively that's it. So let's go and have a look at the SMSF will. So finish, and then just that pops up. So again, it's very much like a BDBN, where we're looking at specific people, but we can make it lump sums, death benefit trusts, and you've got a lot wide open opportunity there. Now, if you want to get legal sign off, because this is, if you want to get Abbott-Family sign off under the SMSF will, you can still prepare it. Then what will happen is you send it to us, book in a time with Tony Anamoulis. Tony will then go through the SMSF will with you. The cost on that is $495, and then that's signed off under Abbott-Family. So for those of you who are accountants and you're concerned about the licensing rules, you can still facilitate this process. For those of you who are planners and you're concerned about whether your licensee will allow you to do this, you can still facilitate the process, but you're handing it off. You're simply going through and handing it off to Abbott-Family lawyers, where we take on the responsibility. And because we're exempt under the licensing rules, we're fine. So effectively, you can still charge the $2,000 or $3,000 or $1,500 you want to with a client, but effectively, there's going to be a $495 fee. We do probably, so far, we're doing about 2 or 3 of these a week, where we set in a Zoom. The client comes with the Zoom, we go through the documentation. In some cases, it's been both the will and the SMSF will. We go through the whole process and then sign it off, have a recording, and then you're off and running. Again, then it's fully under Abbott-Family, and we take all the legal responsibility. Then you don't have to worry about the Legal Professions Act and all of that sort of stuff as well. Now, it's because it's dealing with a benefit, we have to do a product disclosure statement. Let's just go down to the SMSF will itself. The first step is an application. So we've got the application to the trustee by John Smith to accept the SMSF will. So remember, we said we're going to give him a draft tomorrow. So he's coming in tomorrow, and then we'll set 16th of January, he's going to come back and be finalised. So this is final. You're having a meeting with Tony. Tony will go through. If all things being equal, everything's happy, then the client will sign. Tony will witness the signatures at the time of the client going through via a Zoom link, a conference, and then you're off and running. So the request the trustee to accept. So here's the SMSF will. So the first one is we're revoking all early death benefit nominations. Now, if you haven't done an SMSF will for yourself, it's a great way to start and think about it through the process we just did. Appointment of a replacement trustee and member. So we've done that for the company anyway. So if we've already upgraded the corporate trustee, it's built into the company there as well, but it also is covered off into the deed. Death benefit payments. So we've got the lineage there. So I'm not sure what happened. Oh no, we didn't go through the pension, so sorry about that. So death benefit payments, so there should be 3.1. Lineage is on the way down from John. Bloodline for John could be parents, brothers, sisters. That's why I prefer lineage if you want to go way down. So the difference is bloodline is anyone who's got your DNA. Lineage is only those with your DNA who are actually below you. So son, Matthew Smith. Medical rooms at 10 Smith Street, Sydney, New South Wales. Details will be paid to SMSF Death Benefits Trust only. Now, we've got here this benefit may be paid as an income stream if allowed under super laws or transferred directly to any trust, but we've got a death benefit, so it's actually only going to be through the trust. Now, if Matthew's not alive, in the event that Matthew Smith's not alive, then their share of the deceased superannuation benefits will be paid to Matthew Smith's bloodline children if they are dependent upon the deceased member. Remember we wrote that? Under the same terms and conditions as directed for the original beneficiary, either directly if the super laws allow. So if that's the case, then it can be done through the trust only. Alternatively, we could take that trust only out if I want to. So the SMSF Death Benefits Trust. So then we can still do the SMSF Death Benefits Trust for Matthew, but if we've got Matthew not alive, then his children could be paid an income stream. So the medical room's still staying there, but effectively it's by way of an income stream. Now, interesting, just doing that, let's say that's the case, it goes here. Can Marie challenge that? What do you think? Remember Marie, it's over her dead body. No, you have a look at Katzengrossman, Donovan, all the cases. She has no standing because this is a contract under the SIS Act. She's got no standing if this death benefit trust is created. It's not created out of the will. She can only challenge under Family Provisions Act. Have a look at it. Anything that goes into the will. What's gone into the will so far? Nothing. Now, if there's no beneficiary alive at the time of death of the member, then their share of the deceased death benefits would be paid to the deceased estate for the sole benefit of the deceased bloodline or lineage, unless an SMSF Death Benefits Trust can be established. So if it goes there, then obviously, if Matthew's not there, his children effectively can go to Marie and Sally, so they can fight over it. Now, spouse, Sally Smith, she's got $800,000 or whatever my super benefits X other dispositions, which is the amount above, but she could take that as an income stream because she's a spouse. In fact, it's probably worthwhile for her to receive the income stream. Now, again, can Marie challenge that? No, not at all. So we have a look at, if you look at that, that's straight out of Donovan. Now, if Sally's not alive, then their share of the deceased is going to be paid to Marie Smith. So that's not a bad one. And then otherwise it goes to the estate. Now, another part of the contract is John Jacobs from Jacobs Accountant is to be appointed as professional, ensure this death benefits direction nomination are properly attended to at reasonable time. So your fees are normal specialist partner fees. So as soon as it dies, then effectively we're bang on in there. You'll be looking after the estate. And if super benefits are not payable because there's obviously a compliance issue, then it's going to be up to the trustee of the fund and it's got to be payable directly to the lineage. So signed by John, witness 2 signatures. That's the process. Attended by, I forgot to put that in, obviously. When you see this, it means you've forgot to fill a form. So I just have to go relaunch it again. Remember how I do that? Go into the vault, relaunch it, find the file, and then I simply change that. And then obviously the trustees resolve to do that. We've got John, Sally and Matthew. And so that's effectively, when we have a look at it, it's pretty simplistic. Go and try it for yourself, but that's quite, if you have a look at it just for that case and circumstances, there's not really anything that can't be looked at in those terms. But the main one, when I have looked at it, is that we've kept everything siloed in that SMSFs. Now, again, the best way to learn, there's two ways of doing it. You can either go down the track and keep on effectively learning on the job. Alternatively, the SMSF Wills $99. You can start working with myself, start with your own clients if you want to, but if you can, come the 23rd to 24th of March, we're only having 30 people there. We've already sold, I think, 5 tickets, and it was only released yesterday. So come up, I'm going to do a 2-day succession estate planning. We're going to be going through 5 different scenarios and a couple of additional ones that some of our advisors have sent us that will really take us deep into covering most client situations, so that you'll be able to build wills and testamentary trusts. You'll be able to fix up family trusts if you've been reading what I've been sending out in emails, and also SMSF wills really quickly. Now, the benefit out of this is you're actually going to be accredited as a specialist succession and estate planning advisor. So that to me is worth itself. The cost on it is, I think it's $595. I'll just go quickly. We'll just jump out of here. I'll finish up with this. So just to show you where you go, I think I've got my Eventbrite up here. So if you want to go, here's the event. I think it's actually here. So it's just logging in. So sorry about that. So if I go and show you there or view the event. So if I have a look at that, oh, sorry, I've got a little video coming on of the parrots. It's crazy anyway. Funny me. I don't know what that is. Anyway, so we have a look at that. It starts on the 23rd, 24th, starts at 9, finishes at 4, and the ticket is $595. I'm sorry, I don't know. This is this silly little thing that I've got. I don't know where I've got it. Sorry about that, guys. God, I'm dopey sometimes. Anyway, look, I'll finish up there and leave those little parakeets taking us out with that little couple of parakeets talking to each other. Here we go. It's gone now. Just wanted to show you the tickets. So the 3 ticket prices. The normal one is $895. If you're not a member, it's $595. But if you're a licensee or a LY strategist, then it's $545. So as I said, we can see we've got 4 tickets sold, but there's only going to be 30 sold because the room only holds 30. But I'd love to see you up there. But otherwise from that, look, thank you all for coming. From Brian, I've got a grant in relation to the automatic appointment of the LPR as a director of the fund on the death of member. How do you get around CIS Section 80? Still, the LPR has to have consent to the appointment before the member dies. That's good position. So let me just have a look at the legislation. So I'll just jump into the legislation here quickly. And then if you want to jump out, so I'll have a look at this. Good to see you're on again there, Mr. Wibbley. Okay, section 118. Okay, 118. So a person is not eligible for appointment as a trustee or as a director of corporate trustee unless the person has consented in writing to the appointment. Look, good positioning, Brian. So absolutely. So although we put in there into the corporate trustee as that they are a director, there is a blockage there. It certainly doesn't apply before the death of the member. It just simply says it's before their appointment. So they can't be appointed until such time as they have consented to such. Now, I have just done recently appointment of member and director where they consent. So what I need to do is now build a system for you once we've got this as to what happens on the death of a member. And one of those would be the consent of the replacement director. And then once that happens, you'd be able to do your 484, put them in as a director, and then they would take control under the Constitution. But good question, thank you for that. As I said, each one of these processes and systems effectively need to be mapped out. So I've got all of the succession estate planning. We're going to have to do the same thing. And that's another one. Is this why we need to have a specialist super fund EPOA? Absolutely. In fact, I would say that most EPOAs, the ones I've looked at, don't enable enduring power of attorney to act as trustee or director. That's why we put it in quite separately. Good question. So my next step in process, and I'll release this, and I might even get it up and running by I promise I'll have it up and running by 23rd and 24th. A set of systems and procedures which will all be automated of what to happen in the event of the death of a member, and you're looking at SMSF Wills and Death Benefits Trusts and setting up. So I'll have that by that stage. But anyway, thank you all for coming along. I was surprised that there's been so many on, given that it's the start of the year. But again, look, I see there's some great opportunity with $3 trillion sitting in this sector. And look, there's going to be a lot of business there for all of us. But the good thing about it is it's great business, because what we're doing is we're protecting our clients, making sure their families aren't ravaged by fights and also interminable length of delays in terms of trials and getting to a settlement. Plus, obviously, we don't want to get in that place of Taylor versus Miller legal fees. I'll be putting this up onto our system. I'll be doing this. This will go up into our support centre. For those of you who don't know where that is, I'll just show you quickly. Our support centre really has all the nuts and bolts of everything. So if we go to LightYear here, this is our strategy support centre, webinars and training videos, and you've got a whole lot of stuff there. So this will be our December the 9th one. If you haven't looked at it, make sure you have a look at the Moat succession and also estate planner. That's a great one, or the 21st. Anyway, welcome to 2020. Pretty exciting times. I'm really looking forward to this year and taking that next leap in my professional career from SMSF advisor to including that, but now becoming a succession and estate planning specialist. I'd love you all to come with me. Anyway, it's Grant Abbott signing off.